Also in Florida, two young girls have been charged with felony aggravated stalking for harassing a 12-year-old girl who jumped from a tower to her death. The girls are ages 12 and 14 and are accused of harassing Rebecca Ann Sedgwick by posting comments on her Facebook page after she dated the 14-year-old's boyfriend.
You rushed these arrests quicker than we wanted to is because of this post. Yes, I bullied Rebecca and she killed herself, but I don't give a, and you can add the last word yourself.
Sedgwick became despondent after the repeated posts, so then she climbed the tower at an abandoned cement plant and jumped to her death last month.
I'm just as curious as I can be if the parents are still allowing them access to their electronic devices. But I can tell you this, we'll be monitoring. We'll find out what the rules are why they're under home detention, and if they violate just one rule, we'll put them back in juvenile detention.
I hope they won't do this anymore to any other kids. I hope they get counseling, they get help. I hope their parents realize they need to be more involved with their kids and know what they're doing.
Well, joining now is Florida's court judge, Phyllis Kotey. She is a professor at Florida International University College of Law. Thank you for joining us.
Thank you for having me.
I mean, let's get up to one of the core points here as what is the liability of these pre-teenagers in the death of this girl?
Well, that remains to be seen. That's going to be part of the problem. It's how you're going to show accountability and knowledge on the part of these teenagers or young girls in terms of causing the suicide of the victim. That's going to be a great major hurdle for them.
Now, in terms of how these girls are being treated, the sheriff alluded to the fact that they are now under house arrest and that they still have access to the same electronic equipment they used, apparently, to send this girl to her death. Is that standard operational procedure in a case like this where the weapon is the internet?
You know, it's really left up to the judge. I mean, certainly the judge would have been well within their rights to impose a no electronics or no use of your telephone, but I'm sure their attorneys then would have fought vigorously to say that it was unreasonable to deny them of something so basic as a phone. And that's kind of how people see phones now. That's part of the problem with cell phones.
Now, what kind of punishment do they face in the worst case scenario, at least the worst case scenario for them, if they're convicted of the charges that they're up against?
Well, if they're convicted as adults, I mean, right now they're charged as juveniles, but if they were convicted as adults, they could face up to 5 years in prison. But if they're convicted as juveniles, it will be a determination for the Department of Human Services to decide after they're convicted or adjudicated delinquent, which is the term that's used for juveniles, to determine what the penalty would be. There will be an investigation, and the fact that they have no prior criminal records and no prior contact with the educational system in terms of suspensions would all be taken into account in terms of what sentence would be appropriate.
Phyllis, this is not the first time this has happened in America. Is there any anti-bullying legislation in any other state that sets any kind of precedent for the charges that these young girls face?
There is, but the problem with most of our anti-bullying statutes, and if you notice, they're not charged with under the anti-bullying statute even in this case, is most of it is aimed at our school system, making sure that kids are safe or students are safe in school. And Florida has one of the strongest anti-bullying statutes that exists, and it was just amended as recently as August, adding a cyberbullying element to it. So certainly I think Florida has responded, and what you have to wonder is, what did the school know? Did the parents ever complain to the school? What is happening there? Because if it is found that the school had that kind of knowledge, there's certainly other kinds of punishments that can kick in.
The sheriff has suggested in some of his press conferences that he might even arrest the parents of these girls that are now under house arrest. Is there any legal standing for a statement like that, or is this grandstanding or whatever based on his passion about this particular case?
Well, I mean, and he certainly sounds passionate. I think at the very least, parents can always be charged with contributing to the delinquency of a minor if it's known that they knew about the conduct and they did nothing about it. or negligent supervision. But again, I think those would be very, very difficult evidentiary hurdles for any sort of prosecutor to cross.
So, you know, in the case, let's say that all of these agencies were involved. No, let's say the teachers knew. Let's say the school knew, and let's say the parents knew. Ultimately, this is a device that is open and free to everyone. Certainly, there was an option for the parents of the deceased child to bring down the Facebook page if they were aware of some problem. I mean, doesn't this kind of stretch the limits of what people are supposed to be watching and intervening in?
Well, in so many ways, it's creative in terms of stretching that kind of belief standard that we're going to impose. I mean, part of the problem with even the aggravated stalking charges, how we're going to show any sort of intent to harm, intent or threats or threatening to harm that particular individual. It's going to be a problem.
You know, and moving on in terms of bigger things, because we've seen parents arrested for bullying. But in those cases, it mainly involved physical touching of a child, and this is a little bit different. This is definitely new territory. In terms of your dealings with the court, we always talk about how the law or the courts have yet to catch up with the actual technology. Is there some ground here that could be established in this case or in a case like this that would allow the law to catch up with the technology?
Absolutely. I think at the very least, what can be added is a standard that says if your harassment reaches such a level that a person harms themselves, then maybe we can assume there was some sort of intent to harm and allow us to have a prosecution that way. So I definitely think the courts will have some room to grow in terms of how it treats these kinds of crimes.
Certainly, the history of these two juveniles will play a role. You have any intel at all on what kind of children they were, or are they looking at possibly probation? Certainly, that always plays a factor. Do you have anything you can tell us about that?
Certainly nothing I've seen so far has suggested any sort of knowledge on the part of anyone. I mean, in fact, one of the parents saying, my child would never even say or do such a thing. So you have to wonder, if there's no knowledge about any of the behavior, what were the parents doing and where were the parents?
Certainly a question that could be asked through the ages, and certainly one with the internet we'll be asking in many different ways. Phyllis Kotey, thank you so much for joining us.
Thank you very much.
And this is Arise America.